Hello, everyone. We're going to wait just a couple minutes before we begin to let some more people trickle in. But thank you for joining, and we'll start shortly. All right, everyone, let's get started. Thank you again for joining us. This is on behalf of Texas Legal, and we will be talking about estate planning and consumer protection. Our agenda. Um, all right, I'll be speaking a little bit to introduce us, and Christopher Doran is here with us as well. So after our introduction, we'll be going into our estate planning section and then going into consumer protection. And then we'll be closing up a little bit with how Texas Legal can help you get access to these services, as well as a Q&A session. So you can submit your questions along the way, but we'll be answering them at the end. And then we'll go into a little bit description of how you can take advantage of a free legal consultation with our attorneys that are participating today. Christopher, would you like to go ahead and tell them all a little bit about GoToWebinar and how they can participate?
Yeah, thanks, Allison. So, hi, everyone. My name is Christopher Dorn. I'm Vice President of Marketing with Texas Legal. First off, I want to thank your fantastic HR team for having us here today. We have close to 225 people attending today's or registered for today's webinar. So, obviously, a huge interest in how to protect yourself against consumer issues, and then also getting your legal estate in order. For some of you, this might be a first time on a webinar, so we want to just quickly run through housekeeping. First off, this is being recorded for future reference, for use within your organization. So we're going to be recording it, but the beauty is ourselves and our panelists are the only ones who could talk. You are all in mute mode. So if you have questions, you'll see within GoToWebinar that you have the ability to post questions on the bottom right-hand side. We'll be collecting those throughout this session and give our attorneys a chance to answer them at the end of the session. Now, we might not have a chance to get to all of them, so we'll do our best. If you do not, we don't have a chance to answer your question, or if it's best answered one-on-one, we'll be in touch after the session to answer them as best we can. A couple other resources there we have some data sheets. One is around getting your estate in order in the different scenarios, and it's in the handout section within GoToWebinar. And the second is about Texas Legal. For those of you who are not aware of us, we are your legal insurance provider. We allow you to purchase protection to get your estate in order and protect yourself against consumer issues and up to 35 different issues. So we're really excited to be here today. So one other thing to note is our attorneys here, for those who are attended, are here in Austin, and we are here in Austin, but Texas Legal is across the great state of Texas, so we have over 500 attorneys in our network. So while our guest speakers may be here in Austin, if you are interested in speaking with another attorney, please go to our attorney finder, and you can see the attorneys that we have in our network across the state, because we realize that your organization is across the state as well. So We are not limited. We are just lucky enough to have our speakers here today. So let me take a moment and actually just introduce or tell you a little bit about our guest speakers. We have two fantastic attorneys on the line today. And first off, I want to personally thank them both for taking time out of their busy schedule to come and speak with us. Liesl Rickhoff is an attorney and counselor here in Austin. Her focus is on wills and probate and disability planning. And our second speaker is Sade, and she's going to be talking about consumer protection, real estate law, and debt collections. So once again, I want to thank both of you for attending today. And again, if you have questions for both of them during their presentation, I learned a ton just going through their practice session. Please ask them on the right-hand side. And as Allison mentioned, they're kind enough to offer everyone on the webinar today a 15-minute consultation to answer questions about anything you'd like. So we're going to provide their contact information at the end of this session. So without further ado, let me just tell you a little bit about Texas Legal in one slide. So we are actually your legal insurance provider. And for those of you who are not aware, legal insurance allows you to pay a small monthly fee to protect yourself against legal issues, everything from getting your state in order to consumer protection to elder care, identity theft and monitoring. And we're going to be sending you information after this just to tell you a little bit about Texas Legal. You received significant discounts on our plan through your employer benefits package. And we are a nonprofit actually founded by the lawyers of Texas to help Texans get the proper protection that they need should they need an attorney. We're regulated by the Department of Insurance, and we have over 500 attorneys in our network. So the beauty of using our plan is you get to choose the attorney that meets your need for whatever kind of need that you have in your life. So let's get on to the good stuff. It's my pleasure to introduce Liesl Rickhoff. Liesl, let me hand over the presentation over to you. Take it away.
Hello, and thanks, Chris, for the introduction. I was so pleased to have the invitation to present today because every day I see the effects of what not having a plan has on grieving families. So my hope today is just to educate everyone a little bit, get you thinking, and hopefully light a fire under you. So to start, we can ask, who needs a will? Almost everyone. There's a large misconception that only the wealthy need wills. I often hear from clients, well, I don't have much. I don't need a will, do I? It's simply not true. When someone passes away, their estate, no matter how large or small, will go through the probate process overseen by the probate court. So if you leave probate assets, the probate court will be involved in one way or the other. What are probate assets? Probate assets can include your bank account, vehicles, stock, personal belongings, the things you have in your house, your blender for Pete's sake. So if you plan on owning anything at the time of your death, it's important to know the probate court will be involved, and a will minimize the cost and the time associated with going through probate court and managing your final affairs. The second misconception I run into a lot is, well, I don't need a will. My kids will get everything, right? Or I don't need a will, my spouse gets it all, right? Wrong. That's not the state's default. The state has what's called intestacy laws, and those are the laws that dictate who receives property should someone pass away without a will. So I wanted to take a look at a few scenarios depending on common family trees, and this will help if you take a look at the charts on the slides and follow along. It really helps to have a visual with what I'm speaking on. So let's start with a married person with children. You're married with kids. If you owned any property before marriage, that's your separate property, and only 1/3 of it is going to your spouse. Separate property is also going to include any inheritance you received during your marriage. So again, if you received any inheritance during your marriage, 1/3 to your spouse, the rest to your children. Now, land is treated a little bit differently. That's real property. So let's say you purchased or signed a loan on a home before you were married. Well, your spouse is only going to get a 1/3 life estate in that home. And that's that little triangle coming out of the circle on B. The rest of your land is going to your children. That's not the ideal situation for most people. Things get a little more complicated if you have children from a previous relationship, if you and your spouse do not share the same children biologically. So there's not a slide on this, but bear with me. If you have children from a previous relationship, your share of community property, meaning your 1/2 of all the property that you and your spouse acquired during marriage, is going to go to your children equally. Your spouse gets to keep their 1/2 of everything acquired during marriage, but the other 1/2 will go to your kids if you don't share the same children. So that's the state's default for someone passing away without a will. Some people are okay with this arrangement, some are not. Most would like to tweak it, and that's where planning comes in. That's where having a will is beneficial. So we can move on to scenario number 2. This is the family tree where you are married with no children. Any separate real property you own, that's going to be home, land, that you acquired before marriage or through inheritance, is going to go 1/2 to your spouse. The other 1/2 is going to go to your parents if they're living, or if they're not living, to your siblings. So just imagine a spouse co-owning property with their mother-in-law or their brother-in-law. It's not the ideal situation, and co-owned property often presents legal problems. Legal problems cost money. You can work around this default by giving instructions regarding real property in your will. Okay, and this slide gets a little complicated because it goes from if your parents are living, if only one parent is living, to no parents living, and you have siblings, to no siblings at all. But we can move along to the third slide, scenario 3. And this would be an unmarried person without children. So first we go up. 1/2 will go to mom, 1/2 go to dad if they are living. Otherwise, it'll go to the siblings if there are any siblings. If there are no surviving parents and no surviving siblings, well, then we get to collateral kin. This is going to be grandparents, cousins, people you may not have seen since the family reunion 20 years ago. And here I often see people say, I don't want Cousin Joe to get anything. My friend of 20 years should receive some gift. And unless you have a will, that friend isn't going to receive anything. We have a final scenario. Scenario 4 is unmarried person with children. And this is maybe where the state default has it correct for most people. That is, all your property is equally distributed between your surviving children. Now, if your surviving children, if one of them isn't financially savvy, then it might not be a good idea to have them take their share directly. It might be a better idea to have a will with a testamentary trust that puts that child's share into a trust to be managed by someone a little bit more financially savvy. It all depends on your circumstances. But in the end, if you pass away without a will, you're going to be stuck with the state's default intestacy distribution. It's a one-size-fits-all approach, and most people need a little tailoring. And a will give you that tailoring. It gives you control. Without a will, you simply don't have control. Okay. So I can talk about the benefits of planning now. I always say guidance comes number 1. Your loved ones are going to have guidance during a difficult time if you pass away with a will. I like to think of a will as the last gift you can give to your loved ones, because a well-written will is going to minimize the stress, the costs, and the grief your loved ones will face when managing your final affairs. It also gives you peace of mind that your property is going to be distributed according to your specific instructions. Here, the state doesn't decide, you decide. And that's the way it should be, because you know your family best, you know their needs best, and you should be able to give instructions about the distributions that will benefit them the best. Another benefit of planning here is we have savings. Practically speaking, dying without a will is expensive. Court costs alone and associated fees are roughly $650 more than passing away with a will. And this doesn't even start to include the additional attorney's fees that arise from intestate estates where the decedent has passed away without a will. Those estates require more work, which means more attorney's fees. And depending on the estate and your family dynamics, the attorney's fees could reach into the thousands of dollars. So a will is a worthwhile investment. It more than pays for itself. Okay, the last item I'll stress is that a benefit of planning, it gives you special considerations for minors. A minor can't inherit property outright. If your property passes to a minor by the intestacy laws, or maybe by a poorly drafted will, then the court will appoint an attorney to represent that minor beneficiary. And who pays for that attorney? Your estate is going to pay. So your estate pays for this random court-appointed attorney. And the court will force that minor's share into either a trust to be managed by someone the court chooses, or into the court's registry to be held until the child turns 18. So neither of these two options is desirable. First of all, it's going to cost your estate far more money to have the court make these decisions for you post-death, rather than having a will with a testamentary trust with instructions that give you control. Second, you have no control over who manages the money and how the money is to be spent on the minor. Again, you simply have no control. Third, if the money is placed in the court's registry, it just sits there. It accrues very minimal interest. And lastly, if the money is sent to the registry, it's delivered to that minor beneficiary when he turns 18. So just think how many 18-year-olds you know that can be trusted with any sum of money. It's not an ideal situation. So on the contrary, if you prepare a will with a testamentary trust, then you can designate an age at which your young loved one receives the money. Perhaps you think 21 years old, 25, or for the more financially immature, 30 years old would be a good age to receive their share of your estate. And all the while your beneficiary is growing, your trustee can make expenditures on them for their education, their health, their support. So I'll just conclude with, again, I want to stress the point that not having a will means you don't have control. It means additional stress and more money for your loved ones in an already difficult time. I know no one wants to think about their death, and I know no one wants to speak to an attorney, but a will really, truly is the last gift you can give your family.
Liesl, that's, hey, thanks so much for taking the time. One quick question before we move on. When people meet with you to do a will, are there other documents that you work with them to put in line that are important?
Sure. So a will is going to cover you for your death and help guide your family post-death. But other documents include disability planning documents. So this would be a financial power of attorney, a medical power of attorney, and even a directive to physicians. Most people know what a financial power of attorney is. That's a legal document designating an agent to act on your behalf financially, make transactions. You can make it as broad as you want. You can say your agent can do anything you can do for yourself, your agent can do for you. Or you can make it very limited and restricted and say, my agent can only transact X part of business on my behalf.
Got it. Great.
All
Well,
right.
thanks again for, we have lots of questions coming in, so we'll be back to you in no time at all. Great. Well, the second speaker today is Sade. Sade is an attorney here in Austin who specializes in consumer protection and real estate issues. So without further ado, I'm going to hand things over to Sade, and who's going to talk a little bit about her expertise. Sade?
Thanks, Christopher, and I want to say thank you to Allison also for organizing the whole thing, and thanks for having me on, and I thank everyone that's attending today, taking time to listen in. And just really quickly, yes, I do do a lot of consumer law here in the state of Texas because the states have specific laws, and also the federal laws are out there, but whenever there's a state-specific law, we go with that. So I'm in Austin, but I practice all over Texas as well. And most of the clients that we see tend to come from the Travis and Williamson County areas, just because naturally it's easier for them to hire a lawyer here in Austin. And as far as consumer law goes, there are different types of consumer law. And generally speaking, the government put into place some laws that are designed to prevent businesses from engaging in fraud or unfair practices or misrepresentation, things like that, and protecting the consumers when they're purchasing services or products. So what I've done today is to categorize consumer law in a simple way by putting them into 3 different categories. And the first category is contracts. When we get the cases coming to us at our law firm, usually there's a contract involved because that is what causes a consumer relationship to develop in the first place. So the first thing to look out for is whether you have an agreement with a company or another party. The consumer laws out there are typically designed to protect you from companies because they usually have a higher bargaining power and they're more sophisticated than the average person. So make sure you have an agreement in place. Even if it's a verbal agreement or partially written agreement, it's still considered an agreement. The second category that we look at, or we get a lot at the office, would be the collections cases. And the collections cases are also as a result of a contract or an agreement that already happened in the past. And in the case of collections, the client comes to us because a company is harassing them or accusing them of owing some money or actually suing them for some debt. And some of the times the clients are on the flip side trying to collect money that's owed to them. In terms of credit reporting and public records, that is related to the second category that I just spoke about, because most of the time when there's a dispute over loans or debts, the information ends up showing up on the credit reports. And we all know that the credit rating is really taken very seriously in the Western world. So we have to, we're here to protect consumer rights and make sure that they don't get taken advantage of by lenders, especially, and other companies out there. So right now I'll go ahead and talk a little bit more about what it looks like, what a typical contract would look like. And most of the cases that we get at our office come from homeowners or people that have issues with credit card companies. Sometimes the client, for instance, has taken their vehicle out to one of the better known companies, the chain companies out there that do oil changes routinely, and you would expect that these companies would do a good job. And what would surprise you is they screw up a lot of the times. A lot of people don't know that they have rights, so what they do is send a letter in to the corporate office, or they call over to the manager at the local branch over and over and over again, and they're given the runaround until they give up. So when we step in, we do essentially the same thing, but we put our letter in a more formal way, and we send that letter out. So we get a lot of complaints about the auto repair shops and the dealerships, as well as the finance companies that come with the dealership. So make sure that you're paying attention when you take your car in for a service, or when you're making payments on your auto loan, to make sure you're not getting ripped off. As far as the HOAs go, we get a lot of complaints in regards to the HOA fining people for little offenses that are not related to the rules of the HOA, and that is considered a violation of consumer rights as well. If you're, for whatever reason, behind on your assessments on the HOA or the COA, the Condominium Owners Association, the law actually requires them to work with you to make sure that you're caught up on your payments. So there are laws out there, there are rights out there that protect the homeowners, and we just want to make sure everybody knows about that today. Some of the time, the issue is that the HOA is trying to do a foreclosure on the home, and that's a big deal. So for instance, we had a client coming to us because he was only like $300 behind on his assessment, and the HOA was trying to do a foreclosure, so we had to put a stop to that. Check out all the contracts that you have, with your gym membership. Make sure that they're not charging you more than they had promised to charge you in the first place, because that would be considered misrepresentation, and you would have a right to contest that, the additional charges, because we don't want them to be doing a bait and switch on you. As far as the home warranties and the working with the builders or contractors that are helping you to remodel your home, we get a lot of complaints in that area as well. And the home is the biggest purchase that most people have made. So we understand why people get very frustrated with these contractors and builders. And most of the time it's because the contractor has promised the world and they're delivering very low quality work. They're taking shortcuts and trying to save money that way, and the end result is the homeowner is not satisfied with the work. They're not doing the work to specifications, and so we have to step in to make sure that they're held accountable to their word. So in spotting a breach of contract, you really want to make sure that you've done your part of the agreement. You've held up to your part of the bargain, and the other party is not performing as they promised. Maybe they didn't deliver the right products or the right quality of the services that they promised you. Maybe they promised you A and delivered B, and sometimes they deliver it but 6 months way behind schedule. So those all are considered breach of contract. So right now I will talk really quickly about how we handle it at our law firm, and I think that's probably the same way that most lawyers would approach it, is that, like I said earlier, we first send out a letter. It's called a demand letter, and we warn the other party that our client has a complaint against them. And we outline what our client is complaining about, and we also make sure to mention what we want the other side to do. So for instance, I write a demand letter out saying, hey, you fixed the car, but it's not fixed. And you already charged my client $4,000, but the car is still not fixed. So we would like you to refix, repair the car again, or we would like you to give us the money back. And so when we send that, we put a deadline in there, telling the other party you have 10 days to reply. Otherwise, we might have to go to court to handle this matter. And the demand letters have a high success rate. In my experience, we have 8 out of 10 of them would quickly call the lawyer and say, hey, would like to talk about this, and this was a mistake and would like to settle. And we usually get pretty much everything that we've asked for in the letter. And that includes if you have attorney's fees that you paid out of pocket, or if you had additional costs, say you had to tow the vehicle back home or something like that, then we get all of that money back as well. The other 20%, the 2 out of 10 that don't work, where the demand letter doesn't work, we end up suing the company in court and ultimately putting that much pressure on them and filing the right documents, following through, having a good case to begin with. They tend to settle close to the hearing date. So there's the whole process still works. Some companies are more resistant than others, and they don't want to settle right away because the policy is to say no first and see if the person would go away. So make sure that you know your rights and don't get frustrated and just let it go. You can talk to a lawyer because the lawyer can be more effective than you when it comes to writing out a demand letter. It will be more formal. It will have legal language in there that you probably wouldn't know about, and it has a high success rate. So definitely always contact a lawyer first. And right now I'd like to move on and talk about the collection cases a little bit more. The collection cases are huge because this just goes on all the time. We have a lot of clients calling us. Most of the time we're on the defense side of things. So that means that our client has already been sued by the time they contact us. Some of the time we get people contacting us prior to being sued. The process is almost the same, except that having a lawsuit kind of creates additional urgency to try to take care of the matter fast. So the burden of proof is on the party that sued first. So the person that brought the lawsuit has to prove up the debt. So don't just admit to owing anything just because somebody has sued you. It's good to contact a lawyer first because the lawyer can usually find a defense. Even if you don't think that there's a defense out there, you never know. So there are different types of defenses. I could rattle off 10 or 12 right now, but I won't. And if anybody is interested in talking more about that, I'll be happy to. But most of the time, there's almost always a defense. So don't say, oh, yes, I owe it and I would like to pay. Don't make any admissions at all until you've spoken to a lawyer. Now, as far as either whether you came to us early or later in the game, we can still try to settle the matter if we find out that the debt is able to be proved up. So our first job, my first job, is to validate that debt. If the other party is not able to validate the debt, then I ask for the court to dismiss the case, and we usually have a good chance of getting it dismissed if it's exchanged hands a few times. Most of the debts have exchanged hands quite a few times if they're old debts. What we want to avoid, our main goal is to make sure you don't have a judgment against you, because the judgment can really, really hurt you in terms of your credit rating and your overall credit profile. If you have a judgment on your record, you certainly will not get a home loan. Here in the US anyway. So we try to avoid that, and occasionally people already have had that judgment without them knowing, and then they come to us later trying to remove it, and we can also help with that. So if you don't show up to court, or if you don't talk to the lawyer, or if you try to avoid the constable or process server when they're trying to find you, the case will still go on without you. So we always say don't bury your head in the sand. Open all mail, and if somebody is looking to serve you with something, still accept it, and then the worst case scenario is the lawyer will defend you. So don't try to do that, because they will sneak behind your back and get a default judgment, which is usually way higher than the amount that you originally would have owed. So really quickly, I would say that the cases do settle most of the time. Like I said before, for instance, if you owe $10,000 on a debt, we would usually be able to settle it for about $3,000, which you might not be able to get on your own. So talk to a lawyer, it's worth it. General tips for consumers here in Texas and even everywhere else is to get everything in writing if possible, because the writing helps us to know when somebody has breached the contract. It's easier for me to tell or prove to the court that the other person didn't do what they promised if there's a writing. So read everything before you sign it. If you're not sure what something means, consult a lawyer. It's very easy to do that, and a lot of lawyers would do the consults for free. or next to nothing. And that's really worth the headache that you'll save yourself. Keep all your copies of the documents that they've given you, even if it's just a work order from Jiffy Lube or someone like that. Keep it in a folder where you can reference it later, or take pictures with your phone, because you can always reprint it later in the future. Make notes of all communications when you're talking to the lender, the mortgage companies, especially they give a lot of people the run around when they're trying to do a loan modification, and they deny and deny and deny. So you want to make sure you have good records. Take pictures of any defects that you see on your home, on your vehicle. If you're working with a postal service of some sort and they sent you a package that was damaged, even though you had delivery, the postal insurance, you want to take pictures, because a picture is worth 1,000 words. And record conversations if you feel that is necessary, but don't trap people by doing a recording when you're on your best behavior. So make sure that you're just talking naturally, as always, maybe with the representative from the bank or something like that, but you're allowed to record them without them knowing. And that might be useful to the attorney in the future. So those are all the tips that I have for right now, and we'll be happy to take any questions that you might have. Thank you.
Great, thank you so much, Sade. That was very helpful. And we've had a lot of questions pouring in during both presentations, so we'll be getting into those in a little bit. I just wanted to share with everyone the awesome benefits of Texas Legal. So you've heard from 2 attorneys in the Austin area about their different focuses, and that's actually just 2 of the benefits that we have under Texas Legal: estate planning and the consumer protection. So you can see in this slide that there's a whole gamut of different ones, and then also in the handout, that's actually a PDF of the one of the sides that you see here. And then the other side of the flyer shows a little bit more detail about Texas Legal and who we are and how we started. So feel free to download that if you'd like to check that out. I'm just going to go over a little bit about our plans. You'll see we have a select plan and a preferred plan. And then the pricing is different for an individual versus your family. And that's dependents that are similar to how health insurance is structured. So the under 26 kind of general rule. And then for both plans, we have estate planning and identity theft monitoring and restoration covered. So that's actually one of our biggest goals as a nonprofit, is to be sure that people have their assets protected proactively through a will, and then also having their current assets through their identity and credit monitoring done. So that's something that we're very passionate about, and a benefit that we've added just this year. So if you are a member that's been a part of our plan for, I mean, it could be 10 years or more, you're now in the preferred plan. So go ahead and take advantage of that identity theft monitoring. Give us a call so you can get that set up. But just seeing how these low rates can really save your family and all of your assets can be very important. And then signing up is easy. So you just go online and you can enroll anytime, and then you can also cancel anytime. We're not here to lock you into anything. We just want to help you get your legal matters in order. And then you can also, we recommend that you keep it, because you never know when that random, like as Sade mentioned, someone could file a lawsuit against you, and then if you had canceled your legal insurance, that would be a pre-existing condition. So for as little as $10 a month, you know that you have access to these experts, and they could write you a demand letter for you, or just handle those little things that could potentially be big things if you don't have access to this great benefit. So as I said, signing up online is easy. You just go to our website, texaslegal.org. You'll choose your group so that you can get your discount. And then if you do have any questions along the way, we do have a great customer service. So you'll see that number at the bottom of the slide, as well as you can email us any questions. And then if we don't have the answer for you, if it's a legal one, we can point you in the right direction. So now that we have a whole flooding of questions. Yeah, let's stick. Here's the contact information. If you have something super specific, feel free to write this down and save this slide. If you do have any questions specific to Texas Legal, you'll see my contact information at the bottom. But you'll also see Liesel and Sade's contact information on here as well. Christopher, what do you think about us going into and diving into these questions we have?
Yeah, we got some great stuff coming in here, guys, and please continue to enter all these questions on the right-hand side. We're going to go through as many as we can. Just a quick reminder that both Sade and Liesel have offered anyone on this call 15 minutes worth of consultation to discuss any of your matters. So take down their contact information. We're going to be sending it to you in a follow-up email as well. A lot of these questions we're getting in are very specific, and I highly recommend you contact them direct. You know, we're not going to be able to get into these nitty-gritty details. And again, that's really the value of having an attorney on your side like Liesel and Sade to make sure that you're getting really detailed information and a will and the consumer protection that you need. Just a quick aside to what Allison mentioned, both these benefits are covered 100% by Texas Legal. One question already came in is, hey, does Texas Legal allow us to get our will taken care of? And the answer is yes. In both our programs, getting a will built out for your custom needs is covered 100%. So all you need to do is go to texaslegal.org, subscribe at the rate that you get from your employer for as low as $10 a month, and you get to get your will taken care of. In which case, I think let's go into the first question here, which is a great one. Is Liesel, how much does it typically cost to get a will in order? Oh, hold on one second here. I think Liesel might be on. There you are. You there, Liesel?
Yes. So the cost of estate planning is going to vary from attorney to attorney, but I can tell you, for me, clients that come to me outside of Texas Legal, I will usually charge $1,000 for a couple's estate planning package. So that is two spouses covering their wills, their different powers of attorneys, and any other ancillary documents. Now, with the slide you just showed, Texas Legal is $15 a month for that family plan. You're going to save, what is it, roughly $820 if you sign up with the plan and get covered under the plan. Otherwise, a general price point might be looking at $1,000 to plan for estate planning for a couple.
So not too shabby.
No.
Great. All right. Well, let's. Allison, you want to pick a question here next, and we'll just go back and forth.
Yeah, that sounds great. Let's see. Someone asked Liesel, what should I be thinking about before I come see an attorney to have my estate in order?
Okay, great question. Of course, you want a general idea of the distribution you want. So who's getting what? That's usually pretty easy for people. What's harder is that an estate planning attorney is going to press you for a Plan B and a Plan C. We want to provide for the unforeseeable future. So what happens when your first intended beneficiary predeceases you? Who's going to get their share of your estate? It's a little bit harder for people to think about those plans B's and C's, I find out. And a plan B and C is also going to be for your fiduciaries. So say your executor, the person that's taking your will through probate court and making sure the beneficiaries get their share. You likely have a person in mind that you can trust, but an estate planning attorney is going to want to know, well, if they're too overcome with grief to do this for you, or if they've moved out of state and it's too much of a hassle to be your executor, who's going to be your second in line and who's going to be your third in line? One last note on that question. A lot of people have a difficulty in determining who is going to be the guardian of their minor children should they pass away while their children are still minors. So the natural guardian is going to be the surviving parent, but if both parents pass away, You really do need a plan for who you're going to designate to take care of your children. And that's the hardest decision I see most
Sure.
people with.
All right, I have a question here. This one's going to Sade. I had a car about 3 years ago that got services but never worked. Probably spent around $3,000 on it. I don't have the car anymore, but can I get back this money because of faulty service?
Well, time is usually of the essence, so you could possibly try, but the best time to have tried to do that would have been right after the thing happened. So depending on whether you can still establish proof from 3 years ago, then you might still have a case, but you only have 4 years to pursue anything when it comes to issues with services and things like that. And you would have had to notify the other party of the issue that you had. So you could still give it a shot, but the chances are very low, just because a lot of time has passed and you may or may not have the evidence to show for it at this point.
Great, thank you. So this one goes to Texas Legal. What type of residential real estate legal coverage do you provide? I'll take that one. So we cover 35 different legal issues. Again, the data sheet is actually listed on the right-hand side. You could download it under handouts. One of them is real estate transactions. So you have access to an attorney that specializes, that has a focus on real estate and real estate planning. And I believe, actually, Lisa, you do real estate transactions, right?
It's not a huge focus, but if I can't handle it, I certainly know someone I can pass you on
Great.
to.
Well, again, we have 500 attorneys in network, so you could always, when you join Texas Legal, you can go and search our database of attorneys that have a focus in certain areas. So yes, we do cover personal real estate transactions for contract reviews and negotiations as well. So that is covered as part of Texas Legal. Allison, you have another question there?
Yeah, actually, this one is for Sade. Can a mortgage lender force me to do a short sale?
No, the mortgage lender cannot force the homeowner to do a short sale. The law requires the mortgage lender to tell the homeowner about all different options for avoiding foreclosure. And the homeowner will have to agree to a short sale for that to happen. And for those that don't know what the short sale is, it's just a situation where the homeowner wants to walk away and avoid an actual foreclosure, and they've found a third party that's willing to take the home, and the amount that the third party wants to pay is lower than the balance that's owed by the homeowner. So that's what's a short sale, and it still shows up on the credit report, and it knocks the credit score down quite a bit. So we don't advise it. There are different options out there, and the lender should not be able to force someone into a short sale.
Okay, great. Thank you so much, Sade. I have another one about wills, and I know this one. I had this question when I first started working at Texas Legal. Is there much difference, Liesl, in going to an attorney versus getting a will done with like a service like LegalZoom?
LegalZoom. I put it this way. Why would you have what you've created over a lifetime be determined by a 10-minute fill-in-the-blank form? You spend a lifetime creating your wealth, and you shouldn't trust it to a 10-minute form. LegalZoom, it'll tell you right on their website that they're not a substitute for an attorney, and that they can't provide you legal advice or even an explanation on the different options they're giving you. So you don't know their legal effect when you're clicking through those options. And most of the time when I see wills that come from LegalZoom, when clients come in, it's a lot of times it's worse than had they had no will at all, because they're vague, the provisions are contradictory from one to the next, and it takes a lot of hoops to get it through probate court and resolve any problems that those contradictory provisions provide. One other problem with LegalZoom is that they're just going to give you instructions on how to sign the will. They're not going to be there signing the will with you. And the instructions are very particular. If you don't sign it the exactly correct way, then your will's not going to be valid. And everything you've planned for, all the thinking and planning you've done, doesn't take effect. It's not valid.
You know, and
you end up
worth
paying the
noting,
cost you wanted to avoid.
it's worth noting that the cost is not that different from Texas Legal. You know, you get to sit down with Liesl and get one done for yourself. You know, and our programs with you guys are about $10 a month for the Select plan. You get the will, you have the protection of Sade and 32 other potential legal issues, all for around the same price.
And I also want to throw in, just because someone also asked if, since we cover the cost of a will, does it also cover the cost of a trust? And that is yes, it does. There's a whole group of different things that are covered under the estate planning umbrella, and we cover them. And the PDF that is attached lists those out.
Great. So lots of great questions coming in here, and you know we're going to we'll keep going as you know we have about 5 minutes left here, but we're going to keep going if our attorneys have time. Sade and Lisa, can you go over a little extra? People are dropping some great questions.
Sure.
Great. Let's see.
I have another one about will, and I'm curious about this answer too. Does the Ladybird will need to be filed in the courts?
It should be filed in the deed records of the county, and that's, again, something we can chat about on a consultation.
Okay.
Okay, so another one for Liesl. So if your spouse dies and you have a child prior to the marriage, and the spouse has children prior to the marriage, how is the real property divided?
So you have a spouse and you each have children from a previous relationship. Luckily, the state default without a will is going to give your spouse a life estate in that home. But otherwise, it gets divided. Your half share of the property for the person that passed away is divided equally between their children. Does that make sense?
I think so.
Oh.
This might be one where it's great to sit down. Again, Liesl's happy to chat with you over the phone, but there's a fair number of these real detailed-oriented ones coming in. But I hopefully that answered the question. If not, you're going to have Liesl's contact information and can sit down with her one-on-one. I have one here about student loans. This could kind of fall in both your areas. I don't know. What about student loans being garnished from hold on. Oh, yeah, here it is. What if a collection agency is contacting me regarding a debt against a parent that passed away 10 years ago and then went through probate at death? I believe the debt occurred post-death. Is there any thoughts on that? Well, this one's probably Sade. Sade?
Yes. Well, the last part, I'm not sure whether the debt would have occurred post-death. You know, debt has to be recognized while the person is still alive, but if there's debt while the person at the time of death, then it's usually taken out of the estate or handled by the estate while the probate is done. So normally they shouldn't be able to come after the relatives at all for that debt unless the relative has co-signed for the death. So as far as probate court goes, I don't know how the probate courts would handle debt of the estate, but they're handled through the probate case whenever that's opened.
And I would agree with Sade. They're not going to be able to ask for the money from the relatives. No one's on the hook for that debt except the estate itself. So when you open up a probate administration, yes, you have to pay creditor claims, but there is a list of priority, and there are some certain assets that are exempt and protected by state law for the natural heirs, and so there's a little bit of ways around a large debt a lot of times.
Great. Here's an interesting one, and then Allison, I'm going to hand it over to you. This is more of a comment or question. You know, can I only buy Texas Legal during open enrollment, or can I buy it any time? The answer is yes. You could buy it at any point in time. All you have to do is go to our website, texaslegal.org/join. It's going to ask you what company you're with. Just enter your company's name, and then you can enroll. And you don't have to be. People had questions, particularly about onboarding process. You could buy it at any point in time. So and you can drop it at any point in time as well. It's a month-to-month benefit. Obviously, if you drop it and you need the insurance part, then you're kind of out of luck on that fact. All right, Allison, what do you got?
Here's one that I'm curious to hear the answer of. What if one of your credit collections has passed their statute of 4 years from the last payment? Can these be removed from your credit history?
It depends. So I think this question is relating to statute of limitations. And the statute of limitations just says that the collector may not sue you. They don't have a right anymore to take that debt, to get that debt paid by you, but you can certainly offer to make the payment if you still want to, but they're not required to remove it from your credit report unless it's already been on there for 7 years. So those are two different things. They cannot take you to court for the money, but they can still report it legally until 7 years have passed.
Okay.
So question here regarding Texas Legal, what's the difference between the select plan and the preferred plan? The select plan is the basic plan that offers coverage, 100% coverage around estate planning, everything that Liesl discussed. You save around $900 there, and then ID theft and monitoring protection. So we'll monitor your ID, alert you if there's a chance that there's been activity on your credit reports. And then actually, if you're covered up to $1 million, if you do suffer some sort of loss there, we'll actually cover you for that. And then on the other significant legal issues, there's a 25% discount. You do get some attorney consults in there. Whereas the preferred plan, you pay a little bit more. For an individual, it's $20 a month, but you're covered 100% across those 35 different legal issues. So should a consumer issue come up, you still get all the basic pieces that is in the preferred plan, but you get a whole wide array of other legal issues, real estate transactions, family matters, divorce, adoptions, all those things are covered 100%. So there's a data sheet again in the handout section. You could download it or visit texaslegal.org and you can read everything you need in there as well. Allison, you have anything?
Yes. So we heard a little bit about trust, but I don't really know exactly what that means. And can you explain like that and probate? And this is for Liesl.
Okay, great. The easiest way to think about a trust is that it's a vehicle for asset management. So if you transfer property, whether it be land or accounts, stocks, etc., into a trust, it sits there for the benefit of a beneficiary or beneficiaries, and the property is subject to the provisions or instructions that the grantor has written, the person who created the trust. I think this is what the question's touching on. A lot of people think that they can just avoid probate by having a trust. And in the perfect world, that would be the case. But in reality, it almost never works because, remember from the presentation, if you have probate property, your estate's going to go through the probate process in probate court. So some people will create a trust, they'll put all their assets in that trust and think, great, I've avoided probate. But over the years, they collect more property and they may forget to put that property into the trust. If you have anything left over hanging outside that trust, then you're going to have to go through probate court. But you can always have a will that simply says, anything that's remaining outside of my trust at my death, I want it to go into my trust and be administered per the terms of my trust. That makes it very simple. But the main takeaway here is that a trust standing alone probably isn't going to let you avoid probate.
Okay, thank you so much. So we are at time now. Christopher, could you change the slide? I'd like to remind everyone that you can contact these attorneys directly. They've been generous enough to offer free 15-minute consultations, which is perfect for some of these more specific questions. So feel free to call or email them. I'm sure that they'd be happy to help, and as well as if you do end up needing their services, log on to Texas Legal to sign up, and so you can get your coverage starting. And if you do sign up before the 25th of the month, you will be active the following month. So don't wait until the last minute, but we're here to help for whenever you have the need. Christopher,
And
is there
so,
anything else you'd like to add?
yeah, well, there's lots of questions coming in about Texas Legal. I'm going to throw up that your account manager is Allison Williams, awilliams@texaslegal.org. If you have any questions, feel free to give Allison a shout. She'll tell you about the program, answer any questions, and if she can't answer, she'll get you to the right people within Texas Legal that can answer it. So we didn't get to a lot of questions here. Apologies to that, but this has been a fantastic session. I want to again thank our attorneys for dedicating their time, and we hope you guys found some value out of this. Again, we're going to be sending out their contact information. Follow up, take advantage of the 15-minute consultation. They'll book a time with you, and Allison, she will help you with any questions about Texas Legal. That's about it from my end. Anything else, Allison? Team?
That's good for me. Anything you'd like to add, Lisa or Sade?
Nothing else, just, get everything in writing and open all mail as usual, and consult a lawyer if you have any doubt.
Okay.
Thanks again, everyone. We appreciate your time, and take care. Bye-bye.